Any mention?
Please, my lord.
Thank you, Lordship. Lordship, I beg to mention item number 37. Lordship, the matter may kindly be adjourned for 2 weeks.
Who's other side? You're there. What's 37 about?
Pardon, Your Lordship.
Legally it matter?
It's a BC matter, Your Lordship. BC matter.
I can't hear you. I can't hear.
It's a village employment development matter, Your Lordship. VC
Okay.
matter.
No, not legal it matter. Okay. 2 weeks, yes. At the request of Counsel Petitioner, yes. Yes.
Much obliged.
May it please Your Lordship. Lordship, I beg to mention item number 36, Lordship. I need some time, my Lord.
What's the matter about?
100 hectare mining.
100 hectare mining.
Yes.
Oh.
I am
Prepare the
petitioner.
matter well. We'll have it. We'll hear it.
My Lord.
When? After 1 week?
After 2 weeks' time, my Lord.
2 weeks?
No objection, Your Lordship.
Yes.
Much obliged, Lordship.
Is there another matter pending with Supreme Court on the same on the same subject? Regard to the area of mining? No.
Not pertaining
area.
to the same subject matter,
Not-
Lordship.
Not relating to the subject.
Much obliged, Lordship.
Please, my lord. No, I beg to mention item number 38. I'm praying for a week's time, my lord.
38?
My lord.
Who's the other side?
I'm appearing for respondent number 4, Your Lordship.
What about District Council? Yes?
My lord, I've
No
already
objection.
informed Mr.
30?
38, my lord.
The 2 weeks, yes.
My lord.
Yes, yes. Yes, MS Raji.
Lordship, I beg to mention item number 14, Lordship. 13 and 14 are connected. In item number 14, I just recently received the copy of the counter, Lordship. So I have sent the counter to my client for instruction, Lordship. So I'll just seek 1 or 2 weeks' time, Lordship.
What's the matter about?
This is, Lordship, so far as item number 13 is, I am claiming for that the benefit of the fifth pay commission, Lordship. They are the Home Guards volunteers. And subsequently, when the matter was pending, I have been disengaged.
Oh, yes, that's the Joy matter.
Yes, Lordship.
Yes, yes. What remains there? Nothing.
No.
Now you're out of the job, right?
Yes, true, Lordship.
Then?
My only contention that because whatever the order has to be passed by the Home Guards department, not by the requisitioning authority, Lordship. Here, there is no order from the Home Guards saying that your service has been disengaged.
Okay, after 2 weeks, yes.
Hello,
Yes.
Bless, Your Lordship.
Yes.
May I please, Your Lordship, I beg to mention item number 40, Your Lordship.
Number?
40.
14 only mentioned.
40, Your Lordship.
There's matter 40, okay.
The last matter, Lordship.
Yes, Your Lordship.
Yes.
We need some time, Your Lordship, to file rejoinder affidavit. So
No rejoinder? Why now on the hearing stage?
last time, Your Lordship, I
They said that it'll come under in the hearing list. Meanwhile, if I rejoinder.
Yes,
If
Your
you have not
Lordship,
filed
but-
it today, that means too late.
no,
Sorry.
Your Lordship. I beg 2 weeks time, Your Lordship.
No time for
It's
rejoinder.
already closed, my Lord, if
After
I'm not
1 week,
mistaken.
yes. We allowed you last time. We didn't file it. So, okay, fine. We'll post it for hearing. You put to file in the meanwhile. Now it's come for hearing. Okay, after 1 week, yes.
Much obliged, Lordship.
Yes.
Please, Lordship. Lordship, I beg to mention item 20. Lordship, I pray for 2 weeks' time, Lordship. 20, Lordship. 20.
You're for the petitioner.
Yes, Your Lordship.
Why you keep on taking time to matter? 2 weeks. Yes.
Obliged, Your Lordship.
Obliged, Lordship.
Supplementary list, item number 1.
Yeah, please, Lordship. Petitioner before Your Lordship, praying for transfer of Session Case 22 of 2023 from the Court of the London Deputy Commissioner to the Court of the Judge, District Council Court, Lordship. And Lordship, similar matters are fixed
When's the
on
matter coming
18th.
up?
On 18th.
18.
Yes, Lordship.
This is matter is
along with
for
this.
hearing on
For
18th.
hearing, Lordship.
You're attending appearance on behalf of?
Yes,
I have my KHDC a party, Lordship.
rightly so. Also, they made us. This is an important issue involved.
Yes, you are for? Shomni. I heard Mr. SD Upadhyay issue notice MS S. I accept notice on behalf of respondent number 1 and Mr. Titi of the council is present on behalf of respondent number 2. So those complete. This is a matter for hearing with other similar matters on 18th of 18/3 years.
Item number 2.
Chief, here. I'll take item number 3, Lordship.
Yes.
Item number 2, 3, and 4 are connected, Lordship. I'll take item number 2, Lordship. Here, Lordship, what happened? The term of the
My lord, I have been
list.
assigned item number 2, my lord.
So you do 2, 3, and 4 also was a problem.
Yes, the term has already been
The
expired.
same something I don't understand. That's one panel, same matter, similar in all respects, given to 1, 2, 3.
My lord, because of scarcity of cases also,
No
my lord.
scarcity of cases.
Term has already been expired, Lordship. That Less Employment Council in January last year, Lordship. Despite the expiry of the term, they are not holding.
January last year, meaning 2023.
3, Lordship. Yes, Lordship.
Okay, heard
Despite-
Mr. S.A. Sheikh issue notice. MS Ark only
All the
accept behalf all
respondents,
respondents, no for them to call for. This is the matter after 3 weeks for instructions.
My lord, just because what happened, in some of the places, they are selecting the function instead of holding election.
My lord,
That
we'll
is
take
why in the
instruction on
meantime,
that.
Lordship, no problem, no selection should be made, Lordship. That in the meantime, no selection. Election.
My lord, let us.
That's part of the scheme.
Yes, Lordship.
That there should be election selection.
But there-
can you ask for interim order that you are coming with a prayer that I think that no selection has been held. No election has been held since January. You're saying just now. Now you're saying don't do it.
In the meantime, Lordship, at least no selection. At least election, no problem, Lordship, because they can hold the election.
We'll record
But
that,
so far as, yes.
The pendency of the petition will not be a bar to the respondents to hold elections for constituting the village employment committee to the concerned villages.
Mazul. 2, 3, and 4.
Item number 5.
Please, Your Lordship. Your Lordship, yesterday Your Lordship had asked me to seek instructions as to why she had been transferred again to the District Council. Lordship, this transfer had been made on her own request. On her own, not to the District Council. Initially, after she had filed a complaint, she also made a request that she would not like to be working under those people against whom she's made allegations. So she was transferred to, as Divisional Forest Officer to this place in Forest Resources Survey in Forest Colony in Polo Ground. Here she has also expressed unhappiness, saying that there could be danger, threat to her life.
You will close it.
Then, Your Lordship,
Totally
which is why we have
Very good.
sent her to
My
the
Lord,
District Council, Your Lordship.
My lord,
And the investigation is, internal complaints committee has already started the investigation.
my lord,
She has already
my
been
lord may,
examined, so has the accused
my
been
lord may
examined.
close it, but kindly give me just 5 minutes, only 5 minutes, my lord. Now, my lord, the letter that I was writing, my lord, I said, relieve me from working under the supervision of this particular officer. I've never said transfer me. Now, my lord, if my lord will see at section 12 of the sexual harassment of the Act 2013, my lord, what it says, my lord, I'll very briefly say, on the recommendation, one thing.
1 second.
Yes. Section 12, my lord, section 12 of the Act 2013.
Yes.
This is an action to be taken during pendency of inquiry, my lord. Now, on the recommendation of the inquiry committee, my lord,
Yes.
on the recommendation, the transfer of the aggrieved woman or the respondent.
Yes.
It can be either me, transfer, or the respondent, my lord. Or, my lord, grant leave to the aggrieved woman, my lord.
Yes.
Grant up to a period of 3 months.
Tell the court, you want leave or you want transfer?
My lord, now, my lord, what I am asking, my lord, now since they have transferred me to district council,
Which is totally independent. So you will not
Which is
be
totally
under
independent,
any
so I am-
threat, you'll not be under any...
yes, now I'm okay with that one.
Right.
But, my lord, now this inquiry, because I have been already put into too much of duress and pressure
that,
also.
That will pass orders.
Yes,
with
my
regard-
lord. Yes,
with
if
regard
they
to-
do that,
Of course, I mean,
yes,
it's a valid complaint. I mean,
My
they
lord.
have slept over your complaint.
yes, my lord, my lord.
I mean, they
1.5
have to
months.
expedite it, yes.
Till 2 attempts were made into my life and the police intervention. then they started pulling up their socks, my lord.
We'll pass orders then.
My lord, oblige.
Pass open
Yeah,
court.
there was a slight delay in taking up because
Even
during
then-
the
even
winter
then, see,
vacation,
you
Your
cannot ask
Lordship.
a person has made a complaint, you can't ask them to go and compromise.
No, we
Now,
have
the
never put
perpetrator
pressure
is
on
the
her, Your
perpetrator is
Lordship.
there in the office
Your Lordship,
itself.
this is not
If
a
he is
correct
actually harassing
statement.
an employee,
This is not a correct statement, Your Lordship. There was no pressure on her
No,
to
but
make any
but
compromise.
there is material to show that, that she was asked to compromise.
She was not asked to compromise, Your Lordship.
Is that correct, Mr.
She
Yoga?
was not asked
my
to
lord, I will
compromise.
just-
She was asked to appear before the committee and to meet the committee
That
members.
portion where they asked to compromise, and after you file FIR.
See, my lord, page 27, my lord. Can you look at page 27? This will make it very clear, my lord.
Yes.
This letter is from Member Secretary with reference to the subject cited above, as you have given a written permission
No, we need to
that,
compromise.
that you are not willing to compromise. See, who was
We'll
forcing me
pass
to
orders.
compromise?
No, there was no pressure on her to compromise, Your Lordship. It
Oblige.
was just
Number 6.
You can't ask them to compromise, even make any,
My lord,
in
a
any
gesture to that
gesture,
effect.
anything.
My lord,
They're
oblige.
a bit taken, yes. Yes, MSB Kharwan Lang.
Your Lordship, this matter may be closed.
Where's the council?
Your Lordship, I'm just praying that it may be reflected in the order that the District Council may decide first with regard to Section 5 of the Act.
It's already there in the order dated 11 Jan.
Your Lordship, it may be reflected in the last order in case any confusion.
MS PF Kharwan Lang, on instruction submitted that as the executive committee to hear the complaint has been reconstituted, the matter may be closed. She however praised that while considering this complaint, Section 5 of the what act is it called?
Of the KH8 Khasi Hills Autonomous District, bracketed nomination and election of the same deputy same and electors of Hima Maharam, Act 2006.
We looked into. Yes, so Mr. V. Kantal and Senior Counsel for the response had no objection. Accordingly, this written stands closed with the direction that the reconstituted executive committee to hear the matter will
10
dispose
days.
of within 10 days.
Yes.
Will dispose of the complaint most expeditiously, preferably within a period of 1 month.
I will try.
7.
Why is it mentioned?
I mentioned because this matter relates to the election to the post of Sardar of Nongiri Ilaka. Lord, being aggrieved by the order passed by the Executive Committee.
1 second. Yes.
My Lord, the operative portion is at page 84.
Your respondent number?
I'm the District Counsel, my Lord.
You also special counsel?
Yes.
1 to 5.
1 to 5.
Yes.
My Lord, will come to page 84, last page.
84?
Yes. My Lord, 1, 2, 3, the fourth paragraph. This is what they are aggrieved by. After hearing the parties orally,
yes,
they were asked and given the chance to submit written arguments to substantiate further their claims and counterclaims, especially in view of the fact that the allegations by the complainants relates to matters dating back to more than 2 to 3 years. The parties were asked to submit the written arguments on or before 25/11/2023. However, all the complainants failed to submit their written arguments as directed even after the expiry of the date fixed, 25/11/2023. Whereas both Shri so-and-so and so-and-so were prompt and submitted their arguments dated 22/11/2023. The matter was taken up and considered. The written arguments of both Philinto Rinja and Bewelson Mokhan dated so-and-so, who reiterated their stand, denying all allegations made by the complainants against them. Further, considering the fact that all the complainants have failed to comply with the directions for submission of the written arguments, it appears they are no longer interested in the matter.
Yes.
In view of the position as narrated above, we find no ground to bar Shri so-and-so and Shri so-and-so from contesting in the elections to the post of Sardar of Nongjiri. They are accordingly allowed to take part in the elections as candidates. However, the allegations made under Section 11 of the Act of 1959, where it is accused that Shri Philento Rinja did not hand over documents of Nongjiri Sardarship to his successor as Sardar of Nongjiri, shall be kept alive and be heard in the next hearing of this complaint. So the contention of my learned friend is that we have filed our submissions, but it was not considered. So it appears there was a miscommunication between the executive committee and the officers. I also agree that they
had filed it.
They had filed it. So, my lord, it may be remanded back. And we will decide afresh.
But let the elections carry on.
Yes.
Why should you hold
the election
back
process. Because, my lord, Section 11.
Well, see, one thing, Mr. Shilla, is that your complaint is still alive. Will be heard next hearing.
But it's just that.
Why you want to debar them?
He's not a candidate also, my lord.
You're not a candidate also?
No, my lord.
Then who are you?
No, actually, I'm the acting Sardar, and the joint complaint is with the other candidates, my lord.
Oh, I thought you're a candidate for the election.
There's some miscommunication between the client and me. But
Between
my lord,
you and the client and you.
Yes, my lord. So I was under impression
that
that
it's a miscommunication.
but
last time you said that you were.
But my lord, the main contention here is that since it's reflected, my complaint objection is disposed on that ground that my written argument is not filed.
That we will correct. Yes.
That will be
So only to that extent, my lord. Whatever order they pass, then accordingly, if they say that we are not contesting candidate, let them dispose it on that line also.
The petitioner, by way of the instrumented application, as a sale, the order dated 25/1/2024, passed by the respondent number
Executive committees.
By the, it's not read anyway, by the respondent district council, wherein it has been alleged that the objection filed with the petitioner against the candidature nomination of respondent number 6 to the post of Sardar Nongjiri Eleka was rejected solely on the ground of non-submissions of written arguments. Stop. This court, which order was that? We will state.
12/2.
And by order 12/2/2024, on hearing, the counsel for the petitioner was pleased to keep the said impugn order in abeyance. In abeyance, and as such, the elections to the post of Sardar Nongjiri Eleka has not been held till date. Stop. Next paragraph. Today, Mr. T.T. Knowledge Council, on behalf of the Respondents Council, has submitted that firstly, the petitioner before this court is not a aspiring candidate or a candidate for the said elections, and secondly, the grievance as put up by the petitioner is genuine in as much as due to a miscommunication, the written arguments filed by the petitioner could not be cleared before the executive committee at the time when the complaint was being taken up for adjudication. Stop. It is therefore prayed that as elections are necessary to be held,
yes,
within necessary to be held in Nongjiri Eleka, as it's now functioning without active Sardar also. Who's active Sardar?
It's under administrator.
Administrator.
As a function of the administrator, that orders be passed to. Oh, sorry. Before that, though, no? It appears that the petition may be closed and the complaint be remanded back to the Executive Committee to be heard along with the written arguments as placed by the petitioner. So, next paragraph. Having considered submission to the counsel of the parties, and especially the fact that the petitioner before this court is not an aspiring candidate or a candidate, so no reason remains for keeping the for keeping the election process in abeyance. Stop. However, it's directed that stop. Accordingly, this matter stands remanded back to the Executive Committee, who shall hear the same within
3 weeks.
Within a week, my lord.
Within a week, and shall consider an argument as filed by the petitioner. Stop. With the above note directions, the matter stands disposed of.
Much obliged.
Yeah.
Daily list, item number 1.
My lord, item number 1 and 2 are same. I'll be addressing your lordships in item number 2. So if your lordships would kindly
It's
take
for
up...
hearing?
For hearing? For hearing, my lord. Yes.
It's for hearing?
Yes, yes.
You ready, Mr. Mahanta? Yes.
In fact, it is in the order column, so agreed to be...
Okay, the joinder has been filed.
Yes. But my lord, there is also one thing. Since we are praying for a writ of certiorari, records will also be required. My lord, I may just briefly indicate...
Why records? If necessary, then we'll call
No,
for the records.
no, my lord. Records will be required. How they determine the rent?
Rent, yes.
Yes. Lordship knows...
But according to them, they determine the rent on the rate which is, ancient rate. That's why they...
90 years back.
90
No,
years
it's not
back.
a question of 90 years back. 2 years back, my lord, we have given an example. It was 36 rupees a year. Now for 9 months, it has gone up to 1,18,000. From 36 for a year, and for 9 months, it is 1,18,000. My lord, my submission is very simple. Lordship knows. In matters of tax or rent or whatever it is, there are 3 stages. 1, there is a charging provision. 2nd, the levy. And 3rd, recovery. Now, we are concerned with that 2nd, levy. If the levy is not in accordance with Article 265, then it's the end of the matter. So that is what I will be addressing. And because records will be necessary because the respondents will have to satisfy your lordships.
The defense estates or the cantonment board?
No, I think it has to be by the DEO. 1 and 2.
My lord, records will not be necessary at this stage, my lord. My lord, once I place my facts, my lord, and the law, your lordship will come to
Mr. Choudhury, then you start.
Yes.
Because you see, the chart was given by, I think, by the petitioner.
Yes.
That is, see, the rise in the rent is
yes.
from 72 rupees to 7 lakh rupees. Is
Yes,
that possible?
yes, yes.
If this chart is correct.
My lord, that is absolutely correct. My lord, the sum and substance of the case, my lord, in the British period, leases were given for 90 years, my lord. 30 plus 30 plus 30 is not renewable any further after that, my lord. So the lease rent that was fixed in 1920s, 1930s, my lord. So that 90 years is over, now it is incumbent upon them to vacate the place, my lord, because they are not entitled to any kind of renewal now.
So the stand has changed now.
But
on all these lease properties, it's been renewed.
No, I think my learned friend has exceeded his brief. It is nobody's case. We are not complaining about that they will not renew our lease. The issue is determination of STR, standard table of rent.
Yes, correct. I'm answering that only, my lord.
Yes.
But a 90 years period is over, my lord. It was renewable only for 3 terms, my lord. So that is over, my lord. They don't have any right of further renewal. Now they are staying over in the land, my lord. They are supposed to vacate. They are not vacating. So as a policy measure, government has said that if you want to continue in the land, you will have to pay rent as per standard table rent, which will be determined according to the market price of the land. And that will give you right of occupancy only for 1 year. Next year, again, it will be revised, my lord.
Where is the policy document?
Well, it is there, my lord.
I'll place that.
Can I place the case, my lord?
Yes.
Yes. Well, just to show, if your lordships would kindly take the writ petition 344 of 22, for a moment, please come to page 110.
1 second.
Page 110.
110.
Yes. Now, this gentleman called Balakrishna Thapa, he is one of the member of the association in item number 2, my lord. Kindly see the period. 1st of April 2021 to 31st of March 22. Please come to the 5th column, land rent 36 rupees. Others we are paying, my lord. This house tax, water tax, latrine tax, light tax, this is we are paying as per the bills raised by them. So now my lord will kindly come to page number 108. Now please come to that box. Advance rental occupation charge from 1/4/2022 to 31/12/22, 9 months, 1,18,823. So they owe an explanation, my lord, how this amount has been determined. Now thus determination cannot be at the ipsi dixit of the defense estate officer of the cantonment board. There is a statute. The statute provides a particular mechanism, read with a circular of 1976. Now, therefore, I am saying, my lord, records will be necessary because records will reveal whether determination, and my lord, it's a certiorari proceeding. If they do not produce a record, lordships will draw adverse conclusion.
No, one thing is that the policy is in place.
Yes, I'm coming to it.
Policy is here?
Yes. Now, if a lordship would like to have first, my lord will kindly come to that 2021 rules. That your lordships will get at page number 70 of the writ petition. The earlier rule of 1925-37, those were amended. My lord will kindly come to page number 73. Rule 9 at page 73. Standard table of rents. Has your lordships got it, my lord? Yes. The defense estate officer, in consultation with the district collector or competent state revenue authority, shall from time to time compile in the form prescribed in the Schedule 2 standard table of rent suitable for applications to sites in cantonment having regard to situation of site, nature of soil, use of the site, and rate charged for adjacent agricultural land for building site in the neighborhood. So the mandate is, my lord, standard table of rent will be determined in consultation with the district collector. Now this is, my lord, in my humble submission, is the charging provision where there is an enabling statute.
Yes.
Now please come to page 76. Rule 16.
Yes.
Leases in lieu of expired lease. In our cases, my lord, the lease expired on 31/3/22, that 90 years period.
31/3/22.
Yes.
Okay.
The method of disposing of land and building constructed thereon under a lease granted under the cantonment codes of 1899 and 1912, Secunderabad Cantonment Code 1913, Cantonment Land Administrative Rules 1925 and 1937, and Secunderabad and Aurangabad Cantonment Land Administration Rules 1930, shall be by lease, and manner and period for which the person to whom such a lease will be granted, the size of the holding, rent and premium payable for the same, and form, terms and conditions on which such a lease may be granted, shall be such as may be decided by the central government from such to time, including such instructions and pertaining to submission of so and so, so and so. So, my lord, what is important to notice from Rule 16 is the manner in which it will be done. It will be prescribed by the central government by way of an executive fiat. Now, that lordships will get in the affidavit filed by the respondents number 1 and 2 at page number, my lord, 15.
50.
15, my lord.
Where's the affidavit filed by?
Filed by Mr. Rohit Singh Malan. He is the DEO, Guwahati Circle. So, my lord, when we read section Rule 16 read with this notification, then we get the manner in which the levy will take place.
Yes.
It starts at page 15. I'll have your lordship's kind attention to page 16. para 4. For determining the value of the land, each cantonment may be I'm sorry, my lord. Has your lordship got it?
16.
Page 16 on top,
Yes.
para 4.
Yes.
For determining the value of the land, each cantonment may be divided into zones, bungalow area, civil, shopping, and lesser developed areas. Where in a cantonment there are similar private lands in the neighborhood, valuation of defense land can be based on sale price of the private land. In other cantonments, lands in various zones should be identified with similar lands in the neighboring municipal area, and the sales of the land that have taken place in a particular region in the municipal area should determine the value of the land, corresponding land in the cantonment. For example, the land comprising the bungalows in a cantonment may more or less correspond to the land in the civil lines of a city. Land in civil area for building purposes in a cantonment may be compared with residential area of similar density and income group in the town. Shopping centers in the cantonment may be compared to shopping centers in the town. Where necessary, some allowance may be made for difference in the state of development, distance from central marketing centers and railways or bus terminal, etc. A2 and other is a class of land which are large compact areas not fully developed, may be compared with less developed land in suburbs of the neighboring municipal area. The zones into which the cantonment is divided and comparable areas in the town along with the sales statistics, their analysis and examples selected, together with valuation proposed to be fixed for each zone on different parts in each zone may be submitted by DEO to the collector for his concurrence. In case the concurrence comments on rates of rent adopted in draft STR are not received within a period of 90 days, the DEO shall forward the draft STR to DDE of the command, who shall be competent authority to approve the draft STR with such changes as considered necessary by him. The DD may, if necessary, visit this station to examine the relevant areas in town sales which are proposed to be applied before according his approval. Well, that 6 is very important. Why I'm saying records is necessary. Plans of zones in the cantonment and corresponding areas in municipal limits, sales statistics and other relevant data, complete with analysis and appreciation of the sales, will be retained in safe custody for future consultation as and when necessary.
See how they put the formula
Yes.
in place.
Well, this is the manner in which they are to do. So unless they produce the record, how do we? My lord, they have filed an affidavit which is neither here nor there. The affidavit is as vague as anything. So therefore, my humble submission is, my lord, it says, my lord, lords will also kindly appreciate. Section 114, I think, H of the Evidence Act says, when records are not produced, the court will presume that the records will be less favorable to them.
Okay, we will not go there.
No, I'm just saying, my lord.
That stage has not come.
No, that has come. It's a 226 proceeding. You are not producing, you are feeling shy to produce the records. Now the question is, my lord, this is how, my lord, the determination of the sale value will be done. In other words, in land acquisition...
One second, Mr. Chod. That means what they have done now, STR, they have just taken the rate given by the Deputy Commissioner, I mean.
That too, my lord, in a different context. The specific query has to be, my lord, let me place 2-3 documents, then I'll articulate my argument. Then my lord will kindly come to page 18. Page 18. This is another circular of 11th of January 73. Please come to para 3. In view of the above, it has been decided that for all building sites, the STR shall provide for rates of rent on the basis of 10 square meter for entire area, even if such area is in excess of 1/4 of an acre. Earlier it was 100 square meter. My lord, the basic unit is, even if it 10 square meter also can be identified, good enough. STR for residential purpose will be 2.5% of the market value. That means if the STR is, say value is not 10 lakhs, then my lord, the rent will be 2.5%. Now, my lord will kindly come to page number 33 of their affidavit. Third of May, 62 code go. 3rd of May 2016, 35. Please come to page 33.
Revision of standard STR.
Yes. Now, DEO is writing to the, my lord, Deputy Commissioner. I'm reading from second para. It is intimated that as per instruction issued by Ministry of Defence, Government of India, STR of Shillong Cantonment is to be revised after 3 years, and hence the same is required to be revised with effect from 1/1/18 for the next 3 years up to 31/12/2020. In this regard, it is submitted that Shillong Cantonment is divided into 4 zones and enumerated in Schedule 2, which is enclosed herewith, based on its commercial potential. In view of the above, STR in the format in Schedule 2, along with the map of the Shillong Cantonment, is forwarded herewith in quadruplicate. You are requested to provide the rates in Schedule 2 and return the same in triplicate for our further necessary action and onward submission to higher authorities. So in terms of that policy, my lord, they have taken this step. Now, my lord will kindly come to page 35. With reference to the has your lordship got it, my lord?
Yes.
Page 35. Now, the Deputy Commissioner is writing to the DEO. With reference to the subjects and letters cited above, standard table of rent for the period 1/1/2018 to 1/12/20 as asked for has not been revised as per our records. Instead, we may provide with the same rate with effect from 1/7/15 to 31/12/17 in Schedule 2. I am also returning herewith copies of the zonal plan and 3 copies of the standard table of rent. The standard table of rent, which was forwarded by DO in format, which was never filled up by the Deputy Commissioner, it was returned. On the contrary, it says we have only figure for this period, that is 1/7/15 to 31/12/17. Then, my lord, please come to the next page. Now, what they did, kindly see.
The table.
Yes. Now, please come to Zone 2, my lord.
Yes.
Now, the description part. Part of the bungalow area covering Ledickin College and School, Pine Walk area, Garrison Ground, Old AP, Secretariat Building, partly unit lines, Rocher Road, Bauri Netraloy, Jhalpura, Bazaar and western part of the camp. How can these areas be compared, my lord? One is in the harbor, part of the commercial, and other is Jhalpura is on totally interior locality. So that's not the guideline says, my lord. That was your suggestion, but this was never filled up by the authority. So, since the Deputy Commissioner has not provided you the figures, where from you got the figures? Now, my lord will kindly come to page number this is the letter which just said that it is not there.
So this rates for 1 year per square meter is 10,000, suppose, for this part of bungalow area.
Yes.
That means it's 10,000. That means they have assessed
For
10,000,
my lord,
7,000.
can you imagine?
4,000.
I think I have
Per
to
square
pay.
meter.
No, my lord, if I am to pay, say, for 2,000, say 1,000 square meter or maybe 4,000, 3,000 square feet, am I supposed to pay 1,18,000 for 9 months?
Because 1 square meter will be around 10 square feet.
Yes.
10,000.
10,000. Well, Lord, we are not on figures, or we are on the decision-making process. Yes. Quantum is not an area where we will trouble your lordships. Where is that letter? Where it says that? This. Now, my lord will kindly come to page number 50.
Okay, same affidavit.
Yes. Page 50. Kindly see, my lord, neither the Deputy Commissioner's office, discharged its function diligently, nor the DEO. With reference to the subject and later under reference, I am to inform you, for calculation of rent, the valuation of land is taken into account and rent is calculated as per Meghalaya Urban Rent Control Act. Well, Meghalaya Urban Rent Control Act, it is a statute which determines the relationship of a landlord-tenant relationship. It can't be, my lord, a premise for determining the STR. Now, Meghalaya, the additional Deputy Commissioner furnishes these figures. So, my lord, relevant considerations were not taken into. What is the requirement? My requirement is, my lord, as per the policy, they are to first constitute a committee. The committee will determine the zones, then ascertain the value of the land by taking...
Only 1 second, Mr. Chaudhary. Has this been in other cantonments, same thing has happened?
Yes. No, my lord. Not in all, because for different cantonment, different methodologies are there. As far as, my lord, as per the old rules, my lord, under which we are supposed to be governed, for other cantonments other than, my lord, Pune and all, on the existing STR, they are to add a percentage. Now the Deputy Commissioner says the existing STR is yet to be determined. Those are also aspects are also there.
Now, but this letter speaks as otherwise. He says that the revision of STR or external cantonment with reference to, I am to inform you that the calculation of rent, valuation of land is taken into account, and rent calculated as per the, okay, maybe it's on the wrong premise, but he's given the valuation.
Some valuation.
Yes.
Yes.
And valuation is quite reasonable, Lord, you will see.
No, my lord.
700 rupees per square feet, 7,000 per square meter, my lord.
Per year.
But the land valuation, my lord. Sale value of the land, my lord. 700, I don't think in Shillong anywhere is available, my lord.
No, my lord. The procedure is prescribed with page 16. Please come to page 16 once, my lord.
No, that we've seen. Yes. Leases in lieu of expired leases, that's the thing.
DC is only to give concurrence, not rates.
Okay, please continue.
Yes. Now, my lord, going by, my lord, the circular of 31st of January 76, there are certain steps to be taken before eventually you, determine the rent. Now, those steps are in our humble comprehension, my lord. First, there has to be a constitution of a committee. Rules. Then there has to be determination of the zones. Then, my lord, ascertainment of the value of the land.
You mean to say that we reflected from the records that whether all these steps were taken before they arrived at this amount?
Exactly. My lord, in fact, my lord, in a certiorari jurisdiction, it is the responsibility of the respondents to produce the records and satisfy the honourable court.
So whatever is by affidavit, if they can satisfy, well and good.
No, my lord, where is the affidavit is silent.
Explanations here.
Why affidavit will not do that, I am saying, my lord. Please take our reply. For example, let us come to their affidavit once, then I will take to thee, my lord. Please come to their affidavit, paragraph 2b.
Yes.
At page 2, that in this regard the deponent states that preparation of STR is governed by Ministry of Defence letter dated 31/1/76, that is at page 16, which I have read, they admit. So we are on the same page with regard to that, which inter alia states that for determining the value of the land, each cantonment may be divided into zones: bungalow area, civil area, shopping area, less developed area. Land in various zones should be identified with similar lands in the neighboring municipal area, and sales of the land that have taken place in particular region in the municipal area should be determined the value of the corresponding land in the cantonment. For example, land comprising the bungalows in a cantonment may more or less correspond to the land in civil lines of a city. So they are using this exact language of the my lord circular. So you may kindly skip over to the next page. Then third sentence. The said letter also states that the zones into which cantonment is divided and comparable areas in the town along with sales statistics, their analysis and examples selected, together with valuation proposed to be fixed for each zone or different zones may be submitted by DDO. Have they asserted that this was followed? They have also, my lord, said this is the procedure prescribed. So therefore I said, my lord, their affidavit is vague. Now therefore, my lord, in that para 6 of that page 16, that para 6 where it says they will retain the record. If tomorrow it is necessary, then one can revert to it. So my lord, when they are asserting that they have done it by oral argument, then but it's not evident from the affidavit. Affidavit, just now I have read this paragraph, what it reflects is that this is the procedure prescribed, which they also agree. Now please come to D. That in the instant case, concurrence of the Deputy Commissioner was obtained by Disengaged State Officer on STR of Shillong Cantonment with effect from 1/1/18 to 31/12/20. After expiry of the validity of the STR, the Defence State Officer Guwahati had revised the STR rates based on the prevalent market value of land within the Shillong Cantonment as conveyed by the Additional Deputy Commissioner East Khasi Hills, white letter dated so and so. Subsequently, the defense, that Lordship has seen that letter, that Rain Control Act and all. Subsequently, Defence State Officer Guwahati, white letter dated, had forwarded the draft STR to the Additional Deputy Commissioner to obtain his concurrence on STR with effect from 1/1/21 to 31/12/23, and Additional Deputy Commissioner white letter had conveyed requisite concurrence. Let them produce this letter, my lord. At least we have not been able to see. What does the state say there? Now, my lord will kindly take our writ petition for a moment for one communication, my lord. If your lordship would kindly have page number 63. Or 64, my lord. I'm sorry, my lord. Page number 69. It's a communication by ADC to the, my lord, one of the petitioner. In a different petition. He's one of the petitioner over there. This was an information which was provided under RTI, my lord. With reference to the subject and letter cited above, I am to inform you that standard table of rent of Shillong Cantonment is not maintained or available with the office at present, and it is only on the request that same is computed and made available to authorities. As far as letter dated May 3, 2018 issued by this office to the Defence State Officer is concerned, in Schedule 2, to the said letter, the column showing annual rental value per square meter pertains to valuation of land per square meter in Shillong Cantonment and not standard table of rent as mentioned therein. So they themselves clarified the position. Now please come to the affidavit filed by the ADC, my lord. Para 6. It's filed by one Srimati B. Rani. Yes.
Respondent number? Respondent number what?
Respondent number 5, my lord.
5.
Yes. Please come to para 6.
1 second. 5.
That with regard to the averments...
1 second, 1 second. Mr.
I'm sorry, my lord.
There's a whole bunch of affidavits.
Yes,
here.
yes.
Yes.
There is no continuous pagination. In Guwahati, we have now developed one practice like Supreme Court, recently, of course.
We have it in our office file, but we have tried, we wanted to replicate
so
it.
what
to
we
the,
do now, my lord, continuously.
For the affidavits, we have continuous pagination for our copy. But then we are trying to implement that here also. Because
no,
the thing
recently
is that
in Guwahati, we have done it.
It's done.
It's very helpful, my lord.
Suppose a writ petition is filed, the page comes up to 20, then after it's filed, then the lawyer
as
takes
many
the page
pleadings, it will just go on adding.
It starts with 21.
Yes.
That's done everywhere, all tribunals
Yes,
also. Yes.
Para 6. At page 6 and page 2 of that affidavit by the ADC.
Yes.
That with regard to the averments made in para 8 to 10 of the writ petition, the answering deponent states that standard table of rent of Shillong area is not determined or approved by this office of the Additional Deputy Commissioner, East Khasi Hills, Shillong, as it is outside the purview of the revenue state. It is pertinent to state herein that a perusal of the letter dated 15 to 22 from the Defence State Officer clearly indicates that standard table of rent was prepared on the basis of minimum valuation of land forwarded by the Office of the Additional Deputy Commissioner, East Khasi District, Shillong. Furthermore, it is stated herein that minimum valuation of land was provided unaware of the fact that the same was meant for preparation of STR in Shillong cantonment area. Therefore, the counter signature in Schedule 2 marked as rate was only on the basis of land valuation rate provided by the office of the so-and-so. So therefore, where is the question of concurrence, my lord? They have construed this to be an concurrence.
Yes.
Now that letter is at page 5 of that affidavit, my lord. Page 5, Annexure 1. Revision of standard, that's the subject. Please come to para 2. Minimum valuation of land as per description of our format zone forwarded via your letter under reference in the format Schedule 2 has been prepared by office and same is re-forwarded herewith for your signature, please. In view of above, in the format in the Schedule 2 duly signed by Defence State Office, Guwahati Circle, is forwarded herewith in quadruplet. You are requested to countersign Schedule 2 and return the same in triplicate for our further necessary action and onward submission to our higher authorities. So those are in the pipeline that have never materialized. So how they have determined, my lord, when these steps are not complete? My lord, why I am saying records are necessary, please come to our reply. I will just refer to 3 small paragraphs, my lord, that will make the position clear.
2nd February.
Reply affidavit, my lord.
2nd February.
Yes. 2nd February, no? Yes. Please come to para 3B, my lord. Now, I have already read para 2B of the affidavit in opposition. This is the reply.
Yes.
That in response to the statement made in... Sorry.
2B.
Yes, small b, my lord. 3B. Phase 2.
Oh, your reply.
Yes, our rejoinder.
Your rejoinder is a response same to para 2B.
Yes,
Para
dealing.
3.
Yes. Please
Yes,
come
yes,
to
what is it?
3B, my lord.
Yes, 3B.
In response to the statements made in para 2B, it is stated that while preparing the standard table of rent, the respondent has failed to comply with instructions contained in letter dated 31/1/76. There is nothing on record to indicate that respondents have carried out the exercise contemplated in the said instruction. On the contrary, while each containment is required to be divided into zones, bungalow area, civil, shopping, lesser developed area, in present case, commercial areas have been clubbed with bungalow area in Zone 1 and Zone 2, and result is therefore inconceivable. For instance, the rate quoted for civil area as per Schedule 2 defines as Zone 2 for Jhalpura, being a lesser developed area, has been calculated at par with areas of Bauri Netralaya, which is adjacent to municipal area of European ward of Shillong, having high commercial value. Zone 3 being a pure army area, which is outside the purview of the STR, has been mechanically clubbed with a civil area and added to the zone. Therefore, preparation of zone itself is invalid and incorrect. Furthermore, there is nothing on record to indicate that respondents have drawn up divisions of the cantonment areas with comparable areas in the neighborhood municipal areas along with sales statistics. Their analysis and examples selected together with the valuation proposed to be fixed for each zone or different parts in each zone may be submitted by DEO to the collector for his concurrence. It is submitted that assessing value of land based on comparable sales method of valuation of land is an acknowledged method in the land acquisition cases. Such a method can certainly be adopted in present case. There is nothing on record to indicate respondents even sought the Deputy Commissioner's concurrence on rates proposed to be adopted in the draft STR. In this regard, the opponent seeks leave so and so. It is therefore submitted that examination of above will certainly establish that STR has not been prepared in the manner envisaged by law. C. In response to the statement made in para 2C, it is stated that instruction dated 30th of January 1976 issued by Ministry of Defence mandates STDR for all building sites, irrespective of whether lease thereof is subsisting or expired, shall provide rate of rents on the basis of 10 square meter for the entire area. It makes no distinction between a site covered by subsisting lease and those covered by expired leases. However, STR enclosed with the affidavit of the respondent does not specify the annual rental value, and the same has been left vacant. As such, respondents have not adhered to the instructions contained in letter dated so and so. In response to the statement made in para 2D, it is stated, the concurrence of the Deputy Commissioner East Khasi Hill is required upon completion of requirements set up in the I'm sorry, madam. Is required upon completion of the requirements set out in the instruction dated so and so. In the present case, none of the requirements contained in the instruction dated have been complied with. Further, there is nothing on record to indicate that respondents even sought Deputy Commissioner's concurrence on the rates proposed to be adopted in the draft STR. Now, in response to the statement made in para 2, it is stated that rules of 21 was notified on 1/12/21 and as such procedure for determination of STR as provided under Rule 9 thereof ought to have been adhered to once the said rule came into force. It is stated that Rule 9 contemplates constitution of a committee and requires a consultative process in determining the rent having regard to this site situation of site, nature of soil, use of the site and rates and charge for adjacent agriculture.
Totally, I can get the entire drift. The thing is that your sole contention is that the rates arrived arbitrarily.
Yes.
There was no process.
The manner prescribed has not been followed.
Have not been followed, and so these are totally illegal,
Yes.
and they should be interfered with. Some in substance.
Some and substance. And secondly, we are not saying they have no.
Substantiate that it was necessary to show that there was no exercise. There no such exercise was ever done. No committees ever constituted. The rates arrived. There was no concurrence from the revenue authorities. The zoning also was all wrong. So that's your case.
Yes. My lord, we are never questioning their authority. They have the jurisdiction.
Of course, but in the manner in which it's been done.
Yes.
So if
The
it's
decision-making
prescribed that way,
process
should be done that way.
Yes. My lord, in fact, I am relying on that judgment, my lord, that
Yes.
if a manner is prescribed, it has to be done in that manner.
Yes.
That, can I place the judgment, my lord?
Privy Council.
Yeah. Yeah. I think we have given this citation, 2022 SC Haseniki. I'm sorry, I have a copy, my lord. I'm sorry. 2022 SCC online 909. For the facts, if your lordships will kindly come to the small first para, my lord.
Yes.
The challenge in the present appeal is to an order passed by the division bench of the High Court of Allahabad, whereby appeal filed by the appellant was dismissed. Such appeal was directed against the order passed by learned single judge of the High Court, wherein order dated 27/1/17 passed by the appellant was quashed, and thus consequently candidature of respondent was to be considered and accepted by the appellants. Then my lord will kindly come to page number para 14. Para 14. The argument of Mr. Bhushan that use of different language is not followed by any consequence and therefore cannot be said to be mandatory is not tenable. So argument was, my lord, non-compliance did not entail any consequence. Therefore, the provision has to be construed as not mandatory. The language chosen is relevant to ensure that candidate who has filled up the application form alone appears in the written examination to maintain probity. The answer sheets have to be in the language chosen by the candidate in the application form. It is well settled that if a particular procedure in filling up application form is prescribed, the application form should be filled up following that procedure alone. This was enunciated by Privy Council in Nazir Ahmed, that old case, my lord, wherein it is held, where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Other methods of performance are necessarily forbidden. So this is the principle, my lord. Now, my lord, now it's a taxing statute.
Yes, we come to that, yes.
So all the more necessary. Otherwise, my lord, it will invite the, wrath of Article 265. Then please come to, my lord, para 16. This said principle has been followed by the court in so-and-so, where the law prescribe a thing to be done in a particular manner following a particular procedure. It shall be done in the same manner following the provisions of law without deviating from the procedure prescribed. Similarly, this court in Municipal Corporation versus so-and-so has followed the said principle. Since advertisement contemplated the manner of filling up the application form and also the attempting of the answer sheet, it has to be done in manner so prescribed. Therefore, reasoning given by the division bench of the High Court that on account of lapse of time, writ petitioner might have attempted the answer sheet in a different language is not justified, as the use of different language itself disentitles the writ petitioner from any indulgence in exercise of the power of judicial review. My lord, I was referring to that judgment of the Supreme Court. Of course, I haven't brought, my lord, that when it comes to, my lord, taxation, then as there are three stages.
Yes.
First is charging provision, second is levy, and third is recovery. As I said, my lord, as far as charging is provision concerned, there is an enabling provision. Now levy, there is a manner. Now that manner has been not followed. Now what would be the consequence? The consequence will still be, my lord, it is violative of Article 265, or in other words, it will be without any authority of law. The end result is not that they will be deprived of their, exercise. They can still do it, but they can do it in the manner prescribed. Yes. Which is not our case that you cannot do it. Of course you can do it. It's true, my lord, these are old leases. From time to time you have to assess the value, then levy it in accordance with law. Then we are bound to pay as a citizen, as a law-abiding citizen, we'll do that. But you cannot assume that there is nothing like discretion, my lord.
Yes.
When the field is covered by statute, there is no question of any element of discretion. As if, my lord, the defense estate officer has some discretion and he has exercised the discretion. That's not the way. So
no,
therefore,
whether examine whether subject what they have to say,
yes, my lord,
whether the method that have applied,
yes,
will somehow come within the four corners of this, of the prescription as given. From the, I think we need the records.
No, my lord. In case of taxation, that substantial compliance will not come. They have to do it because, my lord, it entails an adverse consequence. For example, my lord, if a tax can be levied in a particular manner, it can be levied in only that manner.
That manner, yes.
So,
no, I'm talking about assessment.
Yes.
Because assessment is always, they always
no,
question assessment.
I'm not on the assessment. Levy.
The levy, sorry. So that's the
thing. The levy has to be in accordance with law.
The records I can place. We are not shying away from placing the record.
Yes.
So
we'll place the records, my lord.
No, but please, yes.
My lord, only one submission, my lord, because
I think for the present it's okay.
What has been submitted, my lord?
Subject to right of reply, I think my lord is yes.
First thing, my lord, I'll place the records. Second aspect, my lord, and what is more important, my lord, that the rents are, this STR is fixed for a period of 3 years, my lord.
3 years or 1 year?
3 years, my lord.
Okay.
The block of 3 years, my lord. So first STR, the preceding STR, if I will just submit, my lord.
Yes.
One block of period was from 1/1/15. Sorry, 1/1/16 to 31/12/18.
31/12/18. First.
1/1/16 to 18. So basically, we will take like this: 16, 17, 18 was one block, my lord.
Okay.
19 till 21 is one block.
Yes.
18 to 21. My lord, sorry, I'm extremely sorry, my lord.
16, 18, 18, 21, 21 to 25.
Then 20, 18 to 21. 3 years only. 15 to 18. Then 1/4, it will start from 1/4.
This is small, because 3 years will be.
I think it will.
So you're starting from where? You see 1/1/16 to?
Well, I'm sorry, I'll just calculate.
It goes on a financial year basis, or it goes in the annual basis?
Calendar year, my lord.
It goes in the annual manner.
My lord.
So assessment is done from 1st of January to 31st.
My lord, rates are fixed for a period of 3 years, my lord. Rates are revised after every 3 years, my lord.
Okay, that means from 16 to 18?
Was
right?
one period, my lord. 19 to 21 was one period.
18, okay.
18 to 20.
No, it will be 16 to 18, okay. 16, 17, 18. There will be 19 to 21. Yes.
Actually, my lord, it operates in financial year basis. 1st of April to 31st
That's why we're asking. Whether it operates financial year or operates, in the annual?
Going by the levy.
I think it's calendar year, my lord.
No, in the impugn order page 110. You see 114. 18 to 20, January to December. No, come to the earlier.
18 to 20, sorry.
No. Read petition. Go by the last page. One first page. Earlier. There is no clarity.
Yes.
So, my lord, what I was trying to submit, my lord, what is under challenge is the STR for the period 21 to 23, my lord. That is under challenge before lordship. Now, my lord, before this, my lord, for the previous block of 3 years and 3 years prior to that, my lord, there are more or less no changes in the STR, my lord.
From the 90 years ago?
From last 9 years, my lord.
No, I don't understand. Now you are submitting that this STR changed only in this 21 to 23.
My lord, what they are challenging, because every 3 years we have to supposed to determine STR, my lord. We have to notify that the STR for this period of 21, 22 and 23 will be like this.
Right.
So for the period of 21 till 23 we notified, my lord, that they came and challenged before this honorable court in the year 22, I think. 22, okay. My lord. Prior to that, my lord, there was another block of 3 years. Prior to that also there was another block of 3 years. So my instruction is, my lord, there are absolutely no changes or very minor changes in the rates of rent right since 2016 till 2023, my lord. So what has occasioned the challenge at this point of time, my lord? Because whereas there was no challenge to the earlier STRs, my lord, which were also fixed on the same basis, my lord, after obtaining the rate from the Deputy Commissioner, my lord. That is one aspect, my lord.
No, but it's saying that as per the little chart they gave me last time, that it's gone up last year this much, this year it's come to from 76 rupees to...
Additional affidavit.
But I'll just point that out.
Exponential.
My lord, one point I want to clarify, my lord.
Yes. Yeah.
These leases were given in 1920s, 1930s, up to 1940s, my lord, just before independence, my lord. And all the leases are for a period of 90 years, 3 blocks of 30 years, my lord. So at that point of time, my lord, when the lease was given, the lease rent was 1 rupee, in some cases 2 rupee, my lord. And the lease agreement provided that rent will be revised at the rate of 50%.
50%?
On the second renewal. So, my lord, if the lease rent was 1 rupee, my lord, at that point of time, for the second block of 30 years, it will be 1 rupee 50 paise, my lord. And for third block, it will be 2 rupees 25 paise. My lord, those were the rates at that point of time, my lord. And because the increment was also fixed in the lease agreement itself, my lord, the Cantonment Authority has no choice but to go by that. But once 90 years period is over, my lord, now what is required of them is, my lord, because it is not renewable any further, my lord.
Well, we have to come forward and execute fresh leases.
My lord, it is not renewable at all, my lord, now.
I mean, there's no scope for them.
There is no scope for renewal, my lord. Okay. They have to vacate the place, my lord. Only as an interim measure till the government comes out with a final policy, my lord. So what is to be done with the leases? Government has notified that now there will be annual kind of
arrangement,
provided they pay the rent on the basis of current market value, my lord. And for that, the government is prescribed that current rent will be 2.5% of the current market value of the land, my lord.
So you mean to say that this entire exercise dehoves the rules? That you're not required to follow the rules because it's just an arrangement that it's not STR at all. Then is all charging, what you think is charging fair rent as determined by the Deputy Commissioner for the land occupying. Is that what you're trying to say?
Because the policy itself says, my lord, the land valuation, because the Deputy Commissioner Revenue is the competent authority.
What the court trying to understand is that means that this recommendations or the procedure are not to be followed because the leases have expired.
Leases have expired.
And so just as a stopgap arrangement, we are charging rent from them at the market rate as fixed by the Deputy Commissioner. That's your case.
That is our case.
So you're not. It's not incumbent upon you to go to the inter-exercise constitutional committee to study.
My lord, we have done that. My lord, as far as committee is concerned, my lord, kindly see the cantonment rules, my lord, came into force in the later part of 2023. Rate has been notified prior to that, my lord. These rules cannot have retrospective effect, my lord.
Okay, that point was not brought up. Yes.
So, my lord, now your lordship will kindly see.
Now, your case that these rules not be applicable at all. That is your case, right? That that we are charging rent is a totally different what do you call it arrangement altogether. In the sense that the leases have SDR apply where the lease subsisting.
No, my lord.
Then
we are not submitting that, my lord.
Then
we are submitting that we have to the fixation of rent STR also has to be in terms of the guidelines, my lord.
Even now.
Even now.
Even interim arrangement.
The forejourning has to be there, my lord. We have to ask for the rates from the deputy.
Interim arrangement also has to be done as
my lord, and we have done that, my lord.
Okay.
We have done that, my lord.
Okay. Okay, right.
But the rent will not be the British rates of rent, my lord, of 1 rupee or 50 paisa per square meter, my lord. The rates will be in terms of the present market value, my lord. So that is why the consultation or obtaining rate from the revenue department has come into place, my lord. And based on that, we have done that, my lord. Now, my lord, what is more interesting, my lord, though the petitions are pending, my lord, there are stay orders operating. My lord, there are 127 leases in Shillong Cantonment, my lord. I'll just give some figures, my lord.
Yes.
127 total number of leases.
In the entire Shillong Cantonment?
Entire Shillong Cantonment.
Entire areas?
My lord. 116 have expired. 90 years completed, my lord. 16, my figure.
Okay.
11 are left, my lord, and those will expire by 2030, my lord, in another next 6 to 7 years.
Yes.
Now, my lord, 22 of the lessees, my lord, they have come and paid, and some of them they have offered to come and pay the new rent, my lord. Now, because of the pendency of the matter, my lord, we are not able to process their cases, my lord.
Yes. That'll have no effect. Yes.
So, my lord, till the time I place the records, my lord, by next date I'll place the records. My lord, only if some interim arrangement is made vis-a-vis these 22 people who have already paid the rent.
But that, how did that happen? You can't have two things happening at the same time, Dr. Mozika.
Well, when they are not
decided totally. So whether it'll be bound by what? Their own volition they go and give, that doesn't mean
all these are contractual matters. They have the right to waive their right.
There can be a factor which be considered at time finally hearing that these people are there, they've paid, and so they can't be, you can't have two rates operating for the same kind of leases. We can't have that. Whatever it is, that has to be kept on hold. Any fresh, appraisal by you all has to be kept on hold until this matter is over. That's all. Or which way should be done.
Otherwise, also this matter is only of academic interest now, my lord, or maybe for the areas of payment, my lord, because 24 to 27 to 26 is a new block of period, my lord, and we have already constituted a committee in terms of the.
So what are you going to do with the arrears which you have to collect? Then the case will have a lot of meaning.
My lord, this is alive only to that extent, my lord.
Then?
As soon as we come out with a new standard table of rent, my lord, they have to challenge it again. Or on different grounds, if any.
Yes, Mr. Mahanta?
Maybe in fact, what about the record my colleague has said? My simple submission that number 1 point, your lordship will see that they have come across expired lease. The term of 90 years has been expired, all the lease.
All lease expired?
Expired.
Not all number of.
Yes. Those 115 or 16 number what Mozika has given.
Expired.
Expired, your lordship.
Yes.
So, since it has expired, those benefit of 50% enhancement, 30 years, 30 years, 30 years,
It's over.
not over. That's over. And what my colleague is reading about 1921, the rules, the policy, that has come into effect in December 21. This point has to be noted, Your Lordship.
This yes, sorry. Just
The
come
rule
again.
which
Yeah.
my colleague has, for the petitioner, has read out about the policy, that has come into effect in December 2021.
After the rates were fixed.
Because these are done prior to that.
After the rates have been fixed. meaning.
These are done prior to that.
Age
70.
of the petition.
The notification is dated 1st December 21.
Okay. Rules have come to being after December. Yes, after rates fixed, yes. Yes.
Am I clear, Your Lordship? So during this period, Your Lordship, we are following the rules of 1937. Not a big one. That rule 8 is there of 1937 rules.
Page 60 of the petition.
Page 60.
Yes. This read with 31176. I don't think of it.
This is that rule 8.
8. Standard table of rent, Your Lordship. This has been followed. It is not that nothing has been followed, this has been followed. And this period, it comes from, Your Lordship,
This is 1938.
Yes.
Notification.
since they have given the valuation of the market valuation of land, the Deputy Commissioner agency, on that basis, the standard table of rent has been prepared, sent it to the Deputy Commissioner for concurrence. It was approved and concurred.
They say it's not concurred, they say just signed it without...
No, it was approved. Though they have said, in my respectful submission, it has been approved. Your Lordship can see that. At page 59, Your Lordship will see.
59?
59, 58 is a standard table of rent from 1st January 2021 to 31st December 2023.
59 of your affidavit?
My affidavit, Contempt affidavit.
That is respondent number?
3 and 4.
Page 50.
58, Your Lordship. This is the standard table of rent, date of
1st January.
Date of revision 1st January 2021 on top. Date of expiry 31st December 2023. Then Zone 2, that's what my colleague is reading, Your Lordship. The main route 11,428, 8,571 motorable, then non-motorable 6,857. Your Lordship has sent that. Now let us come to the bottom of the left side. Approved by Additional Deputy Commissioner. In page 59.
Yeah, they can't see they are not approved, you mean.
It is signed by agency. So it is not that we are not following the procedure is being followed. Now setting up the committee, what my colleague is saying, that is coming after December 2021. This is prior to that.
Okay. New rules only.
Yes. Since the new rule, as on today, it is in place, recently the other day I had submitted the formation of the committee, your lordship remember, therefore we have expedited the hearing of this case. The committee has to submit a report on or before 15 March. I have given the copy, your lordship.
Yes.
Earlier I have submitted, your lordship.
Yes.
Therefore the hearing has been fixed today, your lordship.
Oh, that's why.
Yes.
It was on a mention.
Yes, it was mentioned by me, your lordship. So the committee has to again revise their rate from 1124 to 27.
As per the...
As per
the
this
new
market value, and they will again do the revision.
Okay.
So my response assumption, since the 1937 rule in place, following the Rule 8, your lordship, there is no illegality committed. It's a plain and simple. Under the authority, they have done it and followed the procedure. Because expired lease, what benefit they have done, 100 rupees, 70 rupees they paid, they enjoy the fruits of it. A small Gudam, your lordship, they also, how many 1,000 rupees comes, your lordship knows that.
Yes.
That's the main half of the center, your lordship. So, my responsible submission, that cannot be equated with this. 1 lakh how much? That has been calculated on the value basis of the market value of the land. And that is coming under 2.5%. Suppose is a
2.5% of the market rate. Annual rent.
Annual rent. So
if 100 rupees is 2 rupees 50 paisa.
So it's not that exorbitant. It's not that exorbitant. The Act says that 2.5% you have to charge. And that is here. Your lordship will see this. The Rule 7. Preparation of S-tier metric units. It has been decided that for all billing sites at S-tiers shall provide for rates of rent on the basis of 10 square meters for the entire area, even if such area in the excess of 1/4 acre. The S-tier for residential purpose will be 2.5% of the market value. So we are bound to calculate on that basis. There is no illegality committed. In fact, there is no case at all made up for interference of this honorable court. The writ has to be dismissed outrightly, your lordship. And no illegality has been committed.
Yes.
So what my colleague is submitting, 22 of them has paid.
They have
Since they
paid?
know they have paid.
They have paid, my lord.
They have paid.
But we have not been able to
Process due to the stay order.
Doesn't matter. This
So
can be...
they have paid.
Yeah, what about the zoning? That question they have, that the zoning has
Zoning
not
has been done. That has been done.
in
Zone 1, 2, 3, 4. 4 zones has been divided. As per that, 37 rows. It is there. In 58, page 58, 59, it is there. Zone 1, respect to commercial areas, so-and-so, Borough Bazaar, Cantonment Bazaar, up to roadside, Luke Road, all these are. Anjali.
Which page of this book is
58,
that?
page 58 of my affidavit.
No, the other regarding that section 8 with regard to STR of 2.5%.
2.5%, your lordship, he has also read it. It is there in the pleading, it is there. My colleagues already read that.
But my affidavit of respondent number 1 and 2, my lord, at page 17.
Okay. Nothing else?
In my affidavit also I have said. So my response assumption, there is no illegality committed, your lordship. Since they enjoy the fruits of the rent for 90 years.
One thing, are all these people who before this court expired lessees?
Yes, all expired. All expired.
Then there's no quarrel with that.
So then the policy of December 21 doesn't come.
Yes.
And there is no illegality committed. We are following the rules of 37.
Yes, state. Anything else? Any authority you have, Mr. Manta? You want to rely upon? Any authority you want to rely upon?
Apart from that, if your lordship calculate that for square feet 10.76, 1 square meter equal to 10.76 square feet. So if you calculate that, this comes to 1,000 rupees.
1 meter.
Yes.
Not in 1,000, 700.
700 something it comes.
Per square meter.
It's quite reasonable. It's quite reasonable. Earlier, they 90
Annual.
years they enjoyed the fruits.
Because Shillong rates.
That's annual rent, 700
Yes,
rupees per
That's
month.
annual value, my lord. Rent will be 2.5% of that.
2.5.
Exactly, 2.5% is
It's
annual
a very
rent.
nominal. Throughout the canton, throughout the country, they are charging.
Yes, Mr. Shulai.
And Lordship may go to my affidavit of opposition. I have given in details everything.
Lordship, going by the relief claim in the writ, there is no relief claim against this.
So that's a relief for you. So no, you don't have any submissions to make. But your affidavit says that you do not concur, or you do not concur to the. How do you answer that? If Mr. Manta showed that that at page 58, 59, that signature of the approval of the regarding the STR fixation on 1st of January 2021, that is shown. How you say that?
If Lordship, can we come to page 52, that is the affidavit filed by the respondent number 1 and 2, your Lordship. The letter of the additional deputy commissioner is very clear, your Lordship.
One and two, that is page, one second.
Yes, at page 52.
1 and 2, that means the affidavit of the union.
Union, your Lordship, yes.
At page?
At page 52, your Lordship. Kindly see, your Lordship, the first paragraph.
Yes.
Type copies, it's very difficult. Lordship, if I may read, with reference to the subject and letter such as above, I am to inform you that countersign in the format in schedule 2 prepared by your office for the bulk.
What do you want to show, Mr. Shulai? What is your point?
My point here, your Lordship, this is only for a valuation of the land, your Lordship, not STR, your Lordship. That has been clarified by the additional deputy commissioner.
So no, for them they're saying that is on the basis of valuation of the land, they are levying the STR, correct?
Yes.
But you have not signed on that other document you signed whereby the rates have been fixed. Why that is at
Lordship, if Lordship can come to the clarification made in the affidavit.
page 59. Yes.
Lordship, can you come to the affidavit filed by the R5, your Lordship, that is the additional deputy commissioner. At paragraph 6, your Lordship, can you come to page 2, paragraph 6.
You are R5.
Yes, your Lordship. Lordship will come straight away to page 3.
Yes.
If Lordship,
No, you just say that it's not determined or approved by the office of the
I'll come, Lordship, fourth sentence from below, your Lordship, from the. Therefore, the counter signature in the Schedule 2 column mark as rate was only on the basis of land valuation rate provided by the office of the additional deputy.
Okay. So your case that this countersign of STR is only for the valuation that was given by you. Okay, yes. Yes. Mr. Chaudhary.
My Lord, I can reply to each one of them, my Lord. Perhaps, my Lord, I must put the facts in perspective. My Lord, to appreciate, I'm specifically...
Only one
yes. Now, I've got the query, my Lord.
Query is that whatever that policy is not applicable because
All
these
right.
STR is
All right, let us
before
all
the
right.
implementation
All
of
right,
the
my
rules
Lord,
in
that constitution of committee is not required. That's the only thing. The rest are there.
Right.
Yes. Now, my Lord, let us put the things in perspective. I'll specifically deal with my learned friend's contention that because the signature of the ADC appears with the countersign approved, therefore there is a compliance. That is his case. Now let us see, my Lord, whether there is a compliance with the requirement. First of all, my Lord, let us assume Rule 1921 rule is not applicable. So it is 1937 rules.
Yes.
Read with, my Lord, still that 31-176.
Yes.
So 37 rules read with 31-176.
Yes.
Okay. Now, my lord will kindly come to the writ petition for a moment. So this was in reply to which letter? 26, na? They're asking for the information. 3518 was in reply only.
Yes, what do you want to do?
1 second, man. Page number 35. Yes. Please come to page 35 of the writ petition, my lord. Their affidavit, sorry.
Whose affidavit? Cantonment
Affidavit
board.
by the, my lord, 1 and 2. No, sorry, 33. First time the DEO requests the district collector to provide this information.
Page 33.
Page 33, my lord. Yes. It is intimated that as per instruction issued by Ministry of Defence,
Yes.
Government of India, the standard table of rent of Shillong cantonment is to be revised after 3 years, and same is required to be revised with effect from for the next 3 years up to 31/12/2020. In this regard, it is submitted that Shillong is divided into 4 zones and enumerated in Schedule 2, which is enclosed herewith based on its commercial potential. In view of above, STR in the format in Schedule 2, along with the map of Shillong cantonment forwarded herewith in quadruplicate, you are requested to provide the rates in Schedule 2 and return the same in triplicate. This is where, my lord, the DEO abdicates his authority. Kindly appreciate, my lord. He says, you are requested to provide the rates. My lord, providing the rate is not the job of Deputy Commissioner. Determining rate is the job of the DEO as per 31/176. Let us be very clear about it.
It abdicated his authority.
Yes. It is the duty of the DEO, my lord. What he will do once he undertakes the exercise, since defense authorities are not expertise on revenue matters, therefore the scheme envisages concurrence of the Deputy Commissioner, because he is the head of the district revenue head. 31/176 at page 16, it clearly says it is the duty of the DEO to prepare it. After preparing in the manner prescribed, that is, after taking note of adjacent land value, he will prepare it and then send it to DC for approval or concurrence. It can't be other way around, my lord. It can't be that based on ADC's letter, they will determine the standard rate. That is what has been done. So, my lord, this is very clear. Now, what does the Deputy Commissioner says? Please come to page 35. With reference to the subject and letter cited above, standard table of rent for the period so-and-so as asked for has not been revised as per our record. Instead, we may provide the same with effect from 1/7/15 to 17. I am also returning here with 3 copies of zonal plan and 3 copies of the standard table of rent. Yes.
Where are you reading from?
My lord.
Where are you reading from?
Page 35, my lord.
I thought you referred to page
35 of the 1/2's affidavit. 3rd of May 2018.
Yes.
And kindly see, reference is 26 to 18, that is at page 33, which I read just now.
What references in?
Subject letter cited, standard table of rent for period as asked for has not been revised as per our record. Instead, we may provide with the same with effect from 15 to 17. I am also returning herewith copies of zonal plan of the 3 standard table of rent. Now, please come to the next page. Now, what she does, my lord, by hand, she puts these figures. Now, this cannot be the basis. If the manner is prescribed to be done in a particular manner, it has to be done in that manner. It is the DEO who will, my lord, defense estate officer, who having regard to the manner prescribed, he will determine, then he seek concurrence. Where has it been done? That's why I'm saying, my lord. That's why, my lord, please come to page 16. It's very important, para 6. After prescribing the procedure. Para 6. All right, that committee part is not there. 21 will not apply. Plans of zones in cantonment and corresponding areas in the municipal limits. Sales statistics. End of the day, my lord, these are very vital. Sales statistics and other relevant data, complete with analysis and appreciations of sale, will be retained in safe custody for future consultation as and when necessary. So they are statutorily mandated to preserve these records. So if these records reveal that they fixed the rate and sought concurrence from the Deputy Commissioner, and Deputy Commissioner gave the concurrence, then we are out of this courtroom, my lord. If not, my lord, the matter has to be remanded.
Remanded, but like they have said that now it become an academic exercise.
No, my lord. Not at all.
The rate from 21 again.
Yes.
For revisiting the
Yes.
entire exercise.
Yes. Yes. My lord, I think, my lord, my learned friend has put up in a different perspective. All that we are trying to say is, it is the duty of the defense estate officer.
Exactly, but the only point is with regard to the manner of concurrence and whether his abdication of authority by the, he did not do it. He passed the buck.
Passed the buck.
But the thing is that you see in that thing he's cancelled out his road rates and sent it back. Where's that page?
And my lord, can your lordships discount the affidavit filed by the ADC?
No, we cannot discount that. Yes. The affidavit says that only on valuation. And there stands that valuation was received and 2.5 as per the
my
rule.
learned friend is, all my learned friends in unison is saying that it is very reasonable. How much tax you are paying? You are staying outside the cantonment. What is the state land revenue rate, my lord? In Guwahati, we pay rupees 1 or 2 rupees per bigha, per kotha. So, my lord, end of the day, why in cantonment area people will pay more when in the just, my lord, maybe outside that cantonment area people are still paying 2 rupees, 3 rupees? My lord, let us not make everything a commercial venture. It's a developing country, my lord. Our economic, priorities are something else. We have not become a rich country. We are trying to catch up. Let's not become overnight, my lord.
Courts only to see that rule
so
of law.
Therefore, my lord, it's a clear case.
Where commercial considerations.
Where perhaps
if the rent comes to a million rupees for a certain amount of land, if it's justified, court can't interfere.
My lord, last time that's why I'm saying lordship will not go by the figure.
My lord, only one point, my lord. I'll just.
Anyway, my learned friend will say, my lord. Therefore, my humble submission is, my lord, you are putting the cart before the horse. First you determine, then you seek concurrence. That's the procedure. If from the records it reveals, it's well and good. Otherwise, my lord, the process has to be reversed and remanded.
Yes.
Well, my affidavit, my lord, page 36.
One more thing, my lord, before my learned friend starts, perhaps, my lord, my learned friend was arguing against his affidavit. He was arguing against 31-176, but his affidavit starts with 31-176. Kindly see paragraph 2, my lord, of the affidavit of respondent number 1 and 2, para 2b. In this regard, deponent states that preparation of STR is governed by 31-176.
Yes.
So he says, my lord, 31-6 has got no value.
I don't think I said that.
He said 21, yes. Okay. Yes.
But page 36, my lord. My lord, kindly note, my lord, this is for the period, page 36 of my affidavit, my lord. This is for the period 1 January 1918 to 31st December 2020, my lord.
So there's no consideration anymore, you mean?
Not only that, my lord, kindly turns the page, my lord. This is also approved by Deputy Commissioner, my lord, on the left hand.
No, that you've seen.
No,
that was the letter of 3rd May 2018.
That was the impugned one, my lord.
Letter, see, that letter also.
My lord, here lordship will see approved by Deputy Commissioner on the left hand side, my lord,
yes.
And right hand side signed by the DEO, my lord.
Yes, no, that we've seen.
So to say that, my lord, this has been notified by the Deputy Commissioner, in my humble submission is absolutely incorrect, my lord. Moreover, my lord, kindly compare page 36 with page 56, my lord. 56 is the impugned STR, my lord.
Yes.
Now, my lord, Zone 1, Your Lordship, compares page 36 and page 56, my lord.
Yes.
Rate for 18 to 20 block was, my lord, 18,109.
Yes.
In the impugned is 18,429 only, my lord. It's not even an increase of 1%, my lord.
Anyway.
Lordship's got it. I'm comparing 36 with 56, my lord.
So what do you want to show by this?
I want to show, my lord, that the same rates are going on for almost like 9 years.
They paid this 18 to...
They have not paid, my lord. But they have not challenged also this one.
No, never been charged.
Never been charged as 18 rates. So in 18 you're paying the old rates as you paid before.
Because maybe their leases have not expired by then, my lord. Their leases might not have expired.
My lord will kindly come to page 110 of my writ petition, my lord.
My lord, may I clarify?
For a moment.
Yes.
110 of the writ petition. My lord, I paid 2,325 in all. Page one of the member, my lord. His plot number is 49.
1 second.
Land rent is only page 110.
Yes, yes.
So kindly see the period 1st of April 21
So
to
before
31.
that he paid how much?
This much, my lord, 2,325.
No, 18 to... 18 to...
That records we don't have, my lord, but
How much you
prior
paid?
to the impugned demand, this is what we paid.
How much he paid? If it's an expired lease or was it a subsisting lease?
No, it expired on 31/3/22.
Oh, then he
it
paid
was
the old rate. Then
The British rate, my lord, that's not applicable. So, my lord, what I was trying to submit, my lord, the rates have only marginally been increased, my lord.
Only see, Mr. Chaudhary is banging you on only the procedure. He says that
Nazir
if,
Ahmad,
as
my lord.
procedure by
Only
law,
Nazir
is
Ahmad, my lord.
yes, that if you've not done it, as
Nazir
per
Ahmad,
that means-
I think it's a privy council, my lord. We are.
It is privy council, but it's still, that is, it's like a...
Bible.
Yes, you can say it like
Almost
that.
a Bible. My lord, in
Nazir
my
Ahmad-
lord CCL's case, even in contract matters, it has been applied now.
Yes.
So, my lord, as senior counsel is also argued, my lord, these new rules are prospective in nature, my lord, and when we notified, this is not applicable. And now,
No, but you see,
now
the
with
thing is
effect
that
from
if the court finds that, the procedure established has not been followed, so then orders will have to follow. It's like that. But if the court's convinced that, okay, fine, well, let's look at the records.
My
Then
lord, even
do
in
the
such
paper trail.
My lord, even in such case, lordship will direct them to pay at least 50% of the amount, my lord, because they're without paying any rent, my lord. For last several years, they're occupying the land, my lord.
I hope you won't take any other courses of action like asking for termination of the lease. I mean, like
My
eviction.
lease is already
from
expired. They only require eviction now, my lord.
Yes. Anyway, we'll fix it on just for example
the
records. Then then that day you can come with your.
I'll place the records.
Yes, you just show records just for.
But to that effect, one line order passed.
Yes. The matter has been heard at length. In the course of hearing, it appears that the records with regard to the fixation of the STR for the period of 21 to 23 are necessary for perusal by this court. Accordingly, Dr. M. Mozi Khan is directed to produce the relevant records.
20 I can come, okay? 28 March.
20th March.
List on?
20th March will be difficult for me. Little after that.
After that, then it has to be after first week of April. My lord, I could have come on 20th of March. My learned friending is having some difficulty.
I have some difficulty. 21st or 22nd?
No. 21st,
22nd, no.
Next week?
I'll be out of state.
Yes, 21st I can.
21st of March is 21st.
21st, my lord. Yes.
21st.
This on 21st. So the court won't forget also.
But however, your lordship that earlier, the committee has to give the report by 15 March.
So that will not be governed by this case.
Then can the order be there? The committee which said will not be. That can be.
Committee is for the period post.
Yes.
So that's not the.
No, it's for the yes. I thought just Mr. S.P. Manta, Senior Counsel, on behalf of respondents 4 and 5, has, however, apprised the court that for the fixation of the STR for the period
from
1/1/24 to
27,
to 31/12/27, the same has to be issued by 15th of March 2024. In that view of the matter, there will be no impediment on the respondents to engage that said exercises.
Only when the new rate comes, they have to challenge that also.
Let them challenge it. All the better for Mr. Sen. Yes. Yes.
Deeply applied.
All right.
Item number 3.
Your Lordship, in this matter, I've already received the affidavit filed by the state. However, in fact, I'm a little bit confused whether the counsel for the state is presenting all the state respondent, or because in the cause title of the affidavit, they stated that an affidavit in opposition on behalf of the respondent number 3.
Your Lordship, I filed an affidavit on behalf of respondent 3, Your Lordship. And the other respondents will rely on this affidavit filed by respondent 3. I'm appearing for
7. You appear for 7, correct?
For 5, yeah.
Who's appearing for 7?
We are appearing for 7 also. Your Lordship, number 3 and number 7 have filed affidavits separately. So the other state respondents will rely on their affidavits.
MSN inquiry submits that the respondents 1, 2, 4, and 6. And
Yes,
6.
Your Lordship.
6, 9, 7.
Management committee also.
Yes, Your Lordship, we were asked
an
to.
affidavit filed by the respondent number 3. Stop. Your name? You're on number 5. MSP Mauri is present on behalf of respondent number 5. Will post of a hearing?
No, Lordship, I'll file the rejoinder regarding this.
Next, Kharnong Bak is allowed to file rejoinder. The affidavit is allowed just after 2 weeks for rejoinder affidavit. Yes.
Obliged, Your Lordship.
Item number 4.
Yes, Mr. Datta, you've not been well.
Yes, no, Lordship, I'm suffering from high BP. So I pray for 3 weeks' time, Your Lordship, to file the rejoinder.
Rejoinder. 3 weeks' time as prayed, allowed to petition for rejoinder affidavit to. I was filed with 3 and 4. You're not filing affidavit.
Lordship, 1 and 2, I'm representing respondent number 2. We are not filing affidavit.
Okay, MS P. Agarwal submits that no affidavit be forthcoming. On behalf of respondent number 2, submit that respond. This said respond. Yes.
Obliged.
Item number 5.
May I please, Your Lordship?
Yeah.
I'm praying for 2 weeks' time to file my affidavit.
How much time?
2 weeks' time.
Why no one appeared last time for the petitioner? Not interested in the case.
I'm not aware, sir. Aware,
You
Your
don't know about the
Lordship.
case also. Gaubura matter.
Yes, Your Lordship.
What about the other? Has been served all the only 2 respondents. How much time?
2 weeks.
2 weeks for the time granted to the respondents counsel to file affidavit this thereafter.
Much obliged.
6.
My lord, this is an application for release of bill, my lord. And on the last occasion, my lord, I have made a submission that all the documents which have been enclosed in the writ petition are their document. So, my lord, the corporation has actually gone through this also, my lord. In a way, my lord, some of the amount which is claiming is not proper. So, my lord, my prayer is at annexion number 6, that is page 61, there is a representation of November 2023, which is still pending, in which the petitioner has also reflected the amount which he is paying for the corporation, my lord. So, they are still pending.
Page 23.
My lord, page 61, annexure 6. 61 of the writ petition. So, my lord, may kindly dispose of this matter, directing the corporation to dispose of this writ petition, my lord, and then we may also show the actual amount which we are actually, as per our calculation, my lord. So, this.
Yes.
I have no instruction, Your Lordship. Just give me time to take instructions.
It's on Monday. To enable the petitioner counsel. You understand what counsel has said? Said that we will address the representation, rationalize the bills, and see how much you have to be paid.
They can be also present, my lord, when a disposal has been made. They can be part of the meeting also.
Be part, yes.
So we can clarify to them this is the amount that we are supposed to pay.
Be here Monday.
7.
To enable the counsel to obtain instruction, this is a matter on Monday. Monday is the 4th. Yes. Yes.
On the last date, the petitioner had sought time for filing the rejoinder.
May I please, Your Lordship? Your Lordship, I pray for 2 weeks' time to file rejoinder affidavit.
There's a contractual matter also.
The matter is about
It's a matter of contractual employers.
2 weeks' time as prayed. Allowed to pressure for rejoinder.
Much of it.
8.
May it please Your Lordship. Your Lordship, my humble prayer, Your Lordship, I may be allowed to rectify the name of the respondent number 1, Your Lordship. Due to oversight, we have made some clerical error, Your Lordship. And it has been reflected as Rixi Armarak instead of Ricardo Armarak, Your Lordship.
Number 1?
Yes, Your Lordship.
Reflected as?
Rixi Armarak instead of Ricardo Armarak, Your Lordship. Chief Secretary.
What do you mean by name? Secretary, is it a committee? Secretary, is it a committee?
Is this a contempt?
Are you having some personal allegation against number 1?
Your Lordship, this is it's a contempt petition, Your Lordship.
Oh, the contempt, okay.
Yes, Your Lordship.
Sorry. This MSLD Sangma submits that due to
Your
inadvertent.
Lordship. TN Marak, Your Lordship.
Oh, sorry, TN Marak submits that due to inadvertence, the name of respondent number 1 has been shown as, and even the Rixi Armarak is a woman.
Yes, Your Lordship.
And he's shown as Shri also here.
Lordship.
The name of the respondent number 1 has been wrongly shown. She prays that she may be allowed to correct the cause title to indicate the name of the correct person, namely Ricardo.
Ricardo Armarak, Your Lordship.
Ricardo Armarak. Prayers allowed. Petitioner may correct the cause title, the cause of the day.
9.
My Lord, I have filed a miscase in this case, my Lord. I want at least the miscase to be disposed. My Lord.
Miscase? What defect is there in the petition?
My Lord?
What defect was there?
My Lord, that has been cured already. A typing copy I have annexed, my Lord. Now, my Lord, I have filed a miscase.
What are the miscase? Huh? Only one miscase. Where's the miscase?
Miscase is there, my Lord.
Number?
Miscase number 4.
This number 4 for
Yes.
carrying defects?
Yes. My Lord, page number 13 is the impugn order, 8/1/2024. My Lord, by this order, the Honorable Election Tribunal, my Lord, has allowed the condonation petition. The relevant portion, my Lord, I will just read, my Lord. Page number 14, my Lord.
Yes.
Fifth paragraph, my Lord. After minutely considering the submissions and documents on record, this tribunal finds that there is no inordinate delay in preferring the election petitions, and though the petitioner erroneously filed a complaint before the executive committee, followed by filing a writ petition instead of a petition, as provided under the Act of 1959, that the delay, if any, is caused by the misadventure before forum, not covered under the Act of 1959. However, the observations of the Honorable High Court in its order dated so-and-so was not put to challenge by the respondent number 1 before any other appropriate forum. Hence, this tribunal is left with no option but to agree to the fact that the respondent number 1, as it is apparent, accepted the observations and finding of the Honorable High Court in its judgment and order dated 6/12/2022. My Lord, may kindly come to the order dated 6/12/2022, that is in the main writ petition, my Lord, page number 25. Operating part, my Lord, is page number 27.
Yes.
Paragraph 4. Having heard the learned counsel for the parties and examined the act in question, it is correct that no appellate remedy is prescribed in the United Khasi Jaintia Hills Autonomous District Administration and Elections of Sardar of Maulong Act 1960. However, it is also seen that it is not indicated anywhere that the parent act of 1959 will have no applications with regard to the election dispute. In this view of the matter, this court deems it fit to close these writ petitions at this stage by following the petitioners to approach the respondent number 2 with the challenge to the elections of Sardar of Maulong. On such approach, it is open for the respondent to consider the said applications on merits. However, it is expected that a liberal approach will be taken for condoning delay, if any, in filing the said petition. Now, because of this paragraph 6, my Lord, the Honorable Tribunal has come into a conclusion that because this observation has been made by this court, the condonation applications has to be disposed in their favor. My Lord has never stated anywhere that this has to be decided without going on to the merit of the case. Now, my Lord has in paragraph 6 has categorically stated that needless to add, the entire process shall be in accordance with law as laid down.
Yes.
Now, suppose, my Lord, if the statute provides that any election petition can be filed within an extended period, suppose. There may be a law which may provide extended period. In that case, my Lord, they can consider. And they have the discretion whether to condone the delay or not. But as far as our case is concerned, my Lord, if my Lord will see the Act of 1959, Section 5A, my Lord. Section 5A, dispute regarding election. If within 30 days of the declaration of the result by the returning officer, under Section 4, any dispute arises regarding any matter relating to or connected with the elections or nomination of a chief, the dispute shall be referred by the parties concerned by a petition to the tribunal constituted by the council for the purpose, which shall submit its report and finding at the earliest and not later than 6 months from the date of receipt of the case record to the executive committee for its decision. Now, as far as Section 5A is concerned, my Lord, this has to be filed within a period of 30 days, my Lord. Now, as far as the statute is concerned, it does not give any extended period, and my Lord is very much well aware about the law. Even in the case of Reggie Thomas, my Lord, I have a copy of this judgment. If my Lord will come to paragraph 10 of this judgment, my Lord, I'll just read out, my Lord. Section 69 of the is the mechanism provided by the state legislature as contemplated under Article 243 ZK bracket 2 of the Constitution of India. Once the mechanism provided under the statute provides for a time schedule for preferring an election petition, in the absence of any provision, in the absence of a provision in the statute for enlarging the time, under any given circumstances, no court, whether the High Court under Article 226 or this court under Article 32, 136 or 142 of the Constitution can extend the period in election.
Yes, so you're arguing the entire case, you mean?
My Lord, my only contention is because the election tribunal is proceeding with the case, my Lord, if election tribunal decides the case against me or in my favor, my Lord, filing this case before this court will have no bearing, my Lord.
You mean the whole proceedings are non-est? Who is appearing for the election petitioner?
My Lord, in earlier occasion, what has happened, my Lord, when the notice was allowed, but by mistake probably all the respondent seniors' names was recorded. So therefore, registry said we cannot. They need another direction from the court. Last order.
Well, that will have an effect on the election petitioner if that point is decided.
Yes, madam.
Because another difficulty in this case is that you see, whatever it is, that election and Sardar Mawlang does not prescribe for any remedy.
Right.
To election.
Right.
Correct. So that by via media we're saying, okay, fine, since prescribed, so the Parent Act as it existed
will apply.
Will apply.
Right, madam.
So that's the thing. So how stringent should be the application? I mean, in regard to the, we're not going by what do you call it? What do you say? The other circumstances here.
That is true, my lord.
That's only that to be considered.
That is there, but as far as elections, if any election is held under a statute, my lord, that election
now,
has to be as per the
statute. They came
statute.
for this court within 30 days after election.
They have.
This was within 30 days after the election. They challenged the election here.
No, no, my lord. What
was
they
the
have filed a
matter about?
representation before the Secretary Executive Committee Khasil.
Okay, they filed in 30 days. Yes. Mr. Philemon Ongri.
Yes, 26 days delay, my lord.
No,
if
that
I'm
time
not
when they
wrong.
came when they filed the application before
Executive
the Executive Committee, was it within the 30 days of the election results? Then?
No, but
then
wrong-
are you entering appearance? They have instructions, then we tell.
He can appear. I will serve a copy, my lord.
He'll pay his fees.
In that case, my lord, notice may be issued. But
Yes,
in
no,
the
no,
meantime, my
because,
lord,
no, that's the only point you have to consider.
Right, my lord.
Because the thing is that, see, we have to apply, even the principles of general law also
Right.
when it comes to, we can't be so stringent. If the thing is that, if he had come before wrong forum,
yes,
within 30 days, then naturally he's entitled
now
to some
question
remedy.
will be whether misadventure by the parties, my lord,
It's not
can be considered for
misadventure because there's no
or
other
whether
provision.
that can allow to
We'll
go against the
consider
statute.
that,
my lord.
yes. Where's your writ petition? How is it recorded that Mr. Kanta?
That is order dated 8/2/2024, my lord.
Order dated
8/2/2024.
Now that means
8/2/2024 order dated, my lord.
Oh, that's a mistake. We have all this, actually, this council respondents. This is wrong. Anyway, take down. By order dated 8/2/2024, inadvertently, it had been recorded that Mr. Vijay Kanta, the special counsel for KHDC, had accepted notice on behalf of all respondents. Stop. Next paragraph. It had been recorded that on the same sentence, but Ensign Khan, however, pointed out to the court that respondents number 3 to 8 are private respondents. So, accordingly, the next paragraph, let notice issue to the respondents 3 to 8. Steps were taken within 3 days. Yes, just after 2 weeks. Yeah. If you have come
In the
within.
meantime, my lord, my miscase may kindly be disposed, my lord, because here I have prayed for stay of the proceeding, my lord. Because the main issue is
Any developments before election tribunals will be subject to resolve writ petition.
my lord, that in that event also, my lord,
Yes,
they will continue with the proceeding, my lord. That will not be.
They are the people who come forward only against striking of the names of electoral roll as well.
That is the but
How
they want
the
to set aside the
tribunal
election, my lord.
will have to see whether what impact it had on the entire
Some
election.
deceased will also make voters.
And they voted.
They shown
The
voted.
deceased voted. That is-
deceased persons.
That is.
They voted.
Shown voted. Deceased people. That was the allegation. And Bidara Sidney, there was a complaint before the SIF committee. Instead, within the prescribed period of 30 days.
That cannot be a ground, my lord. That is my submission.
Yes.
Obliged.
Thank you.
We are respondent number.
Yes.
Pursuant to the order of the 15.2 of this Honorable Court, my lord, I have
15.2.
served a
There's not order 15.2.
15.2.
There's only one order here, 8.2. What petition looking at?
There are two writ
There are
petitions, Your
two
Lordship.
petitions.
Oh.
Maybe in the next item, Your
Yes.
Lordship.
In the WPC number 26.
Oh? In 26?
In both.
1 second. What is he saying? Yes. Yes. Yes.
May it please Your Lordship, we'll need some more time, Your Lordship, for the
Shall we
affidavit.
stay the relegation of the petitioner?
Lordship,
3 and 4 you are paying for in this second one
Here,
also.
Your Lordship.
Both the
No,
matters.
my friend, she stated on the
let's
in
see.
the earlier petition she mentioned.
1 second.
13.
13. Record 13 first.
What about 26? 27?
26.
13 is one.
MSE Wanyang, the council has entered appearance on behalf of WPC number 13, on behalf of the respondent number 3 and 4 today. So no further notice called for. What you want to file an affidavit here? She prays for the allowed 2 weeks time to file affidavit. What about state?
Same prayer, Lordship.
Further time, for 2 weeks, I also got to the state. This up to 2 weeks. Now coming to
In this 13 or so, my lord, we have made a prayer for
no, 13 only. Huh? Our managing committee.
Yes.
Then what to do?
Lordship, there are, it's a managing committee approved on 19.1, Your Lordship. Now they are functioning, Your Lordship. Because Your Lordship,
If illegal managing committee, it should not function for 1 more minute also. It
cannot be said, Your Lordship,
yes.
it's illegal, Your Lordship, because there is a meeting and all, Your Lordship.
No, my lord. Presumably there's no meeting. The meeting is without my knowledge.
Anyway, we'll just leave the 13 for the time being.
Yes.
Let's see that 26.
And then in the 26, my lord, I have already served a copy by through Dusty Service, and then they have made.
Yes, sir. 3 and 4. Same parties.
Yes, same party.
You're appearing for them.
She's running away.
No, poor thing. She'll not be. There are no instructions. How will she appear? The same people, but are they aware? Are they aware of this new case? You have
They
to take
have
instructions.
received, my lord.
You appeal for Sardar Domsanrang and Sri Torpunia Sangryang in the first petition.
Same respondent.
Who signed this one? What to do, July?
Give them
You
time.
better come quickly with instructions.
Lordship will.
I think. Otherwise, this one also you can't. Firstly, relegated her to head teacher. Now she's become assistant teacher only. Next order will be she outside the door.
No, let me have some instruction, Your
That's
Lordship.
what happens in these schools. You're fighting the managing committee first, relegate you, cut you down to size, and extinguish you. Is this the signatures? Are you aware of signatures? Yes. Mr. S.M. Sona has produced acknowledgement receipt showing the receipt of notices by respondents number 3 and 4. However, MS Iwanyang appearing in the other connected petition has submitted that she has no instructions to appear in this matter. She pleads allowed to obtain the instructions. So, what to do and for the
Such
interim
time, my
prayer?
lord, maybe stay. Since on the last occasion, my lord had expected.
Yes, Mr.
Still will be considered.
Lordship, the money committee has been approved of 19-1, Your Lordship, and they are now they are functioning, Your Lordship. So
Yeah, no, I'm not talking about management committee. I'm talking about the teachers were relegated to assistant teacher.
Lordship, there was a meeting. It appears there was a meeting. There was a meeting, Your Lordship.
I was never informed. I was in the meeting.
Where's that impugn order?
Page 51, my lord.
Yes, sir.
Of my writ petition. On the recommendation of the managing committee, results.
And no relegating you as teacher, where's that?
Is hereby approved as head teacher.
Yes, to obtain instruction stop. It has been submitted and expired by Mr. S.M. Suna that in the prior writ petition, that is WBC number 11,
13.
13,
number 13, the writ petitioner had questioned the Constitutional Management Committee with regard to Constitutional Management Committee. But however, the said Management Committee has, by an impugn order dated 5th February 2024, relegated the writ petitioner from head teacher to assistant teacher, and have appointed respondent number 4 in her place.
Head teacher.
Stop. If no instructions were sought for from the EAG with regard to this development, the same have not been forthcoming. In that view of the matter, the operation of the order dated 5/2/2024 shall remain stayed, and the situation revert to remain stayed. Yes. See what they do. You file, yes.
Apply, Your Lord.
Just after 2 weeks. At least that will give them some jolt to appear fast.
My lord.
Hearing, item 12.
Yes.
This one was really hard. Lordship, in fact, this matter has been heard on the earlier occasion, and we were asked to submit the bullet point.
We have heard it last year, Your Lordship.
Last year? No, we want to hear. Because I've just had a perusal of the written arguments, you see, we have this case stands on footing, so you have to argue accordingly. You ready?
Yes, Your Lordship.
Yes. Someone hearing?
Salah.
Huh?
Lightly.
With other hearing matters, lalu dorong.
Salah.
This one take some time, other hearing matters.
15. 15.
This is that OBC certificate.
Yes. Babita Das.
Babita Das.
See, you're not even looking at the file, I know.
No.
Yes, why do you ask for time last time?
My Lord, I have asked for with regards to whether there is any list or not with regards to the OBC in the state of Meghalaya, my Lord.
There's no list OBC.
There is, my Lord.
There is?
My Lord, which I have already annexed in the writ petition, my Lord.
Okay.
Annexure 9, my Lord.
Annexure 9.
My Lord.
Page?
Page, my Lord, 50, my Lord, 50.
Yes. Your coach?
Yes, ma'am.
Coach is not tribal.
Which is tribal in Meghalaya.
In the state of Meghalaya, it's tribal now.
It's tribal state of Meghalaya, yes, coach.
Which year? 79 or 70?
79.
79.
Other back classes are Ahom, Bania, Boroi, Boroi, Chutia. Even Nepali, Thapa, Gurung, Lama, everyone, Newar, Lohar, Soloi, Sudra, Das, Odi. Yes.
But as far as I know, my lord, there is no OBC list as of now, my lord. This is very old, 79. State can clarify, my lord, this aspect.
Where's the state?
My lord, if no OBC, my lord, if no OBC in the state of Meghalaya, my lord, certificates are being issued by the Deputy Commissioner's office, my lord.
Mr. Shulai, so EAG, I think you can assist the court. Right. Okay.
2023, my lord.
Is OBC list there in Meghalaya?
I'll have to.
So this is creamy layer, non-creamy layer. That's what is called. What's that other one? What's the other category? Economically
backward.
What is the nomenclature for that? Economically weaker.
EWC. Economic weaker section.
Economically backward class. EBC.
Yeah. Not EBC.
EWS.
EW.
EWS.
EWS quota.
Economically weaker section.
Yes. This is not OBC certificate. This is not EWS.
My lord, the Annexure 7 to that, my lord, the form by which the proper form, she could not be able to get the verified, the proper form. What is the allegation on which she has been, her candidature, purported candidature has been.
How many years she's been out of service now?
Now.
Since she was selected?
Date of
selection?
Date of selection 2021. And date of retirement is in 2057. Man.
They have replied to this election 9?
No.
You replied to this, just showed to Mr. Shulai. Because if this list is there, Dr. Mozika, then it settles the whole case in favor of the writ petitioner.
And they have not denied, my lord. In their affidavit in reply, my lord, they have not denied that annexure.
My lord, page 83 of my affidavit, my lord. There's a letter from Additional Deputy Commissioner Shillong, my lord, saying that
There are no OBC in Meghalaya.
Does not have a list of OBC in Meghalaya.
Then how do you explain this list? Because you can't trust these ADCs now also.
Where is the list? Right. No, she belongs to what? Goan, no?
Goan.
Where is that Goan?
This certificate is Goala, means a milkman community, as backward class under India. Because these selections are OBC for the state of Meghalaya itself, correct? It is only with regard to every particular state.
My lord,
OBC is state-wise.
State-wise, even
yes.
ST state-wise.
Yes.
But ST, what happens?
It has to come from the state.
ST, what happens, my lord? If it is the central post, my lord, then they consider from any state, my lord.
What post is this?
My lord,
it's constable.
Constable, constable, Mahila constable, my lord.
In PSF.
In PSF.
Give her a job, Dr. Mozika. What are you creating hassles? You should qualify in all other respects.
But this is only hurdle.
We'll go by this provisional list.
But DC himself is saying, my lord, by page 83 that there is no list of offices in
DC
Meghalaya.
doesn't know anything nowadays. They were not aware of this earlier communication also. If you ask for records, the records been burned in some fire that happened in so-and-so year.
But,
We'll ask from Social Welfare Department.
but if state can implead as a party, they can file an affidavit.
One implead, he can assist the court, he's Additional Advocate General.
Well, you file an affidavit to clarify this aspect.
But there are no OBCs, I mean, as currently, but whether the reliance can be placed on this
social welfare 79 notification, my lord.
On this notification, where's that certificate given by you?
My lord,
Petitioner is different.
But the Deputy Commissioner saying that OBC, where's that?
My lord, that is at
page 83.
Page
83 of my.
No, given in her favor.
No, not given in her
No.
favor.
She said that an extra 8 page. She said that there does not exist any OBC list.
No. Where you got your?
She obtained it from Assam, my lord.
Assam.
All Assam are backward class association.
Yes.
This is your affidavit?
Yes.
Where 83? 83. Where's the impugn order?
My lord, impugn order is at.
First Adjournment, 22 September. Page 53 of the red petition.
Where's the? Okay, that's the only thing. You had failed to produce OBC certificate issued by State of Meghalaya. There's another one where the one given to you by State of Meghalaya saying that they relied on Assam. Last hearing it showed.
Yes, my lord.
Page 83 to the affidavit filed by the.
No, page 40.
Not that.
My lord, page 48 of the annexure 8.
Page 48.
Page 48, yeah. What is that, 53?
See, we treat it as valid.
Assam.
So, but where is say coach? She's coach, she said.
Yes.
She was the coach community.
Coach community.
Where is that?
Page 49, my lord. All Assam Mother Pecot Class Institution. It says coachman.
Oh, yes. Okay. So anyway, it's, take down the single issue involved in the writ petition is with regard to the OBC certificate produced by the writ petitioner for which employment as constable has been denied after valid selection. Stop. A certificate issued by the Additional Deputy Commissioner, East Harz Hill District, Shillong, dated 2/8/2021, has certified that as Meghalaya State does not have a list of other backward classes, the OBC issued by the Government of Assam be treated as valid. Stop. However, in spite of this assertion, it appears that the Government of Meghalaya and the Social Welfare Department provide a the letter. Provide, this is a list dated 10th October 1979, which has been marked as provincial list of other backward classes in Assam, Meghalaya, has recorded certain communities therein to be considered as backward classes. As this is in conflict with the certificate issued by the Deputy Commissioner, who has stated that there are no OBCs in Meghalaya, the learned Additional Advocate General, Mr. N.D. Shulai, has been requested to assist the court in this respect. Mr. Shulai has Mr. Shulai has submitted that necessary instructions will be sought and the same be produced for the court after 1 week, within 2 weeks. Yes.
10 days.
Within 2 weeks, yeah, this so and so. Let her care, because give her a job. She belongs to the coach community. Just because it's not recognized here doesn't mean that.
16.
Yes. You get to see your bullet points. Already? From your side?
Given.
When? Oh. Mr. Manswet, where's? Yes. That's it. Yes, sir.
Submitted for item number 17.
We'll cover everything. Yes, sir. Bullet points have been submitted by the counsels for the parties. Hearing is concluded. Judgment reserved. Yes. Authorities are given here also? No authorities. Why? We don't want the facts. You should give authorities also.
19, connected.
Miss Ardata, please you to supply authorities by Monday. Yes. Just give citations, yes.
21.
What is this?
Work charge. Minor, this is that work charge. Fifth pay commission. Applicability of fifth pay commission to work charge.
It's been heard once, no?
Yes, my lord. My lord has heard us, and my friend had come up with the plea that there is a provision in the rules which says that in the event of any interpretation with regards to the rule, so you are supposed to furnish a notification.
What notification, Mr. Parasaji? What notification? Oh, recorded order 11/12/2023.
11/12.
You brought them?
My lord, I have asked the department, my lord, but
see the order.
This is 11/12. Attention of this court has been drawn by the learned government advocate to communication dated 23rd March 2020, which is annexed at so-and-so, affidavit filed by the state respondent. A perusal of the same reflects that the letter shows that the decision to deprive the petitioners of the benefits of the pay revision was in view of a decision taken by the government in the finance department. K.P. Bhattacharya, learned GF for the state respondent, has also submitted that the same has been decided by the finance department as per Rule 15 of the pay revision rules. Accordingly, in view of the ambiguity of the decision arrived at by the state, they are directed to produce the relevant letters by which the finance department has arrived at the said decision.
Where is that? Forgot about this.
My lord, my apologies. My lord.
You forgot?
Yes, my lord, not forgot, my lord. I'll require a little more time.
As per order dated 11/12/2023, Mr. Kiwasaji was to produce some relevant letters which are indicated therein. However, today he expresses his difficulty to place them without 1 week's time. 2 weeks' time.
Let it come after 10 days,
2 weeks,
my lord.
yes.
My lord, Rule 15 is interpretation clause, my lord. If there's an ambiguity in the provision, my lord, here there's ambiguity in their decision, my lord. They're trying to.
That's why you want to see the letters. Yes. Records are necessary. How do you arrive at the
The
decision?
letter of the rule is very clear, my lord. There is no classification. If there was any classification, the classification.
No. How did they arrive at the decision? That's all. That's why we asked for the letters.
My lord, my apologies. I'll get it.
Yes.
After a week, my lord.
My lord, I'll pray for
After
10
2
days.
weeks, yes. It takes a lot of time.
39.
What's the matter about?
My appointment is cancelled.
You ready with the matter? So you take up the other matter, huh? Yes?
My appointment was cancelled, Your Lordship. Advertisement was floated, Your Lordship, on the month of June 2020, Your Lordship. And then I was called for the personal interview, and I was selected and placed at serial number 12, Your Lordship, in the merit list. But my appointment was not considered, Your Lordship. The reason that my appointment was not considered is based on the purported inquiry, Your Lordship, that the selection board had committed an anomaly in selecting me, Your Lordship, into the merit list for reason that I did not possess the DLS certificate, Your Lordship. Your Lordship, the selection board, Your Lordship, had considered my appointment based on the situation back then, Your Lordship, during COVID, because my DLS certificate could not certificate could not be obtained on due time, Your Lordship. So on that basis,
What certificate was obtained?
the DLS certificate, past certificate. So, Your Lordship, on that basis, the respondent authority had cancelled my appointment.
You
Your
could not produce your death certificate after the results have been declared.
I was selected in the merit list, Your Lordship, but then my appointment was not considered, Your Lordship. So, Your Lordship, the selection committee, the selection board, Your Lordship,
How long you took to produce certificate?
Your Lordship, I cleared I got my past certificate on 8 April 2021.
And the results were declared on?
And the appointment was
February.
The appointment was is an annexure 16, Your Lordship, page 34.
Page 34.
Page 34.
You're out now totally.
Yes, Your Lordship. And the appointment was made on the 13th of April, Your Lordship. 13th of April 2021, and I got my past certificate on 8 April.
What about this inquiry you're talking about?
The inquiry is at page 30.
And what is the inquiry about?
The inquiry it's on a purported anomalies committed by the selection board, Your Lordship, the office of the SDSAO, Mairang subdivision. Your Lordship, the inquiry it's at page 30.
Oh, you were that time you had not got your certificate.
No, Your Lordship. But I was called for the interview. I had made a representation also because, Your Lordship, my back then my
during interview you produced a certificate.
I had produced the
during the interview. No,
Your Lordship, because there was no chance that the certificate could be declared on due
we'll
time.
take it up then. We'll have to take up the matter. When Mr. Kharmi at 2.
Lordship, at 2 also.
Second half.
I'm ready.
We'll have the other matter first.
Obliged.
Your Lordship, maybe on the next date also, Your Lordship, because I had some urgent work also.
Okay, after a week
I'll
we'll
file
take
my
it.
affidavit. I'll rely on my affidavit.
Yes. After 1 week, yes.
Obliged.
Item 12.
We'll take it at 2 o'clock, the matter. You ready? 2 o'clock.